Section 109 of the Commonwealth of Australia Constitution says that when a law of a state is inconsistent with the law of the Commonwealth, the latter shall prevail and the former shall, to the extent of the inconsistency, be invalid. We have videos in our channel about the elements of this section, and we have also analyzed some cases that relate to the inconsistency of laws. You can access these two videos by clicking on the top right corner and checking out the links provided in the description of this video as well. In my opinion, this particular provision seems pretty straightforward. However, it is not always easy to apply the provision to real life circumstances. So, the High Court of Australia has adopted different tests to scrutinize a state law and assess whether that law is consistent with the laws enacted by the Commonwealth. Generally, we see three tests: the conflict of duties and the modification of rights when there is a direct conflict between the two laws, and the covering the field test, which is an indirect form of inconsistency of laws. Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will look more closely to the covering of the whole field test, articulated by Justice Isaacs in Calburn and further used by the High Court of Australia in more recent cases. In the case of Clyde Engineering in Calburn from 1926, Justice Isaacs expressed for the first time what the covering the field test is. For his honour, if a competent legislature expressly or impliedly evinces the intention to cover the whole field, that is a conclusive test of inconsistency where another legislature assumes to enter to any extent upon that same field. This test was picked up by Justice Mason in Ex parte Maclean from 1930, where his honour proposed that inconsistency depends upon the intention of the paramount legislature to express by its enactment completely, exhaustively, exclusively what shall be the law governing the particular conduct of matter to which its attention is directed. When a federal statute discloses such intention, it is inconsistent with it for the law of a state to govern the same conduct or matter. The covering that field test then proposes that any law of the state that enters or attempts to regulate the same matter, conduct or area that has already been regulated by the Commonwealth, well, that law will be inconsistent according to Section 109. The same happens if a law of the Commonwealth exhaustively regulates an area or conduct which the state law already applies to. As long as there is an intention on the Commonwealth legislature to enter that field or matter, the law of the state that is or enters into the same field will be invalid. There's no need to check whether there are direct inconsistencies here. It is a matter of assessing the intention of the Commonwealth in regulating that which the states have legislated about. But obviously there are a few steps that need to be taken, because how can I know the field? How can I know the intention of the Commonwealth in covering that field? As we're about to see, the answers to these questions are not simple. There's no single test or approach that simply tells us what field we're dealing with, or in the case of the absence of an express intention, whether the Commonwealth really wanted to cover that field or not. Okay, maybe you can see that I'm not a big fan of the covering of the field test. It seems to me to give too much leeway to the Commonwealth and to the courts even ultimately. And I'm not alone. Justice Abbott of the High Court of Australia was a fierce opposer of the covering of the field test. In Stock Motors Ploughs, for example, he said this was a very ambiguous phrase and no more than a cliché. In the Kakariki case, he also expressed some doubts on this test being some sort of rule of universal application. However, this is what the High Court of Australia has been using, so let's look at some of the main points related to the covering of the field test. Let's look at these points separately, starting with how can I identify the field? Well, this is tricky. And it is tricky because the High Court of Australia is often inconsistent in precisely identifying what the field of a particular law is. Let me give you an example. In the case of the Airlines of New South Wales and New South Wales No. 2 from 1965, the two laws seemed very clearly, to me, to fall within the same field. The Commonwealth Act was called the Air Navigation Regulations 1947, and the New South Wales law was called the Air Transport Act from 1964. They both prohibited the operation of certain commercial air operations without an appropriate license. So they both seemed to cover the field of regulation of air navigation, or even more specifically of licensing commercial air operations. But the High Court of Australia found that the two laws had different subject matters. For the court, the purposes of the licenses in the two laws were different, and so the two acts concerned different fields. See, from the outset, you can see how the application of this test can be quite challenging. But let's not despair, let's consider some things here. The best way to identify the field seems to be through the process of characterization. What is this law about? What head of power supports the law? What is the scope of the legislation? Is there an express objective in the law? If we characterize the law and identify the subject matter of both laws, we are closer to assessing whether the field is the same or not. Justice Stephen has suggested we use a purposive approach as well. The purpose of the law may be different, and if that is the case, it would be correct to affirm that the fields of the two laws are not the same. If they regulate analogous conduct, but their purposes are different in regulating that conduct, we may be facing different fields and no inconsistency would arise. Look, I know this is not satisfactory, but hey, I didn't create this, I'm just a messenger, I just work here. The other thing that we need to consider is the intention of the Commonwealth in covering the field. The intention to cover the field can be expressed or implied. If it is expressed, this is an easy one to spot. The law will have a provision usually right at the beginning saying that it is intended to regulate the totality or fully a particular subject matter. That express intention may exclude the operation of state laws on the topic according to the covering of the field test. And look, the intention of the Commonwealth legislator can also be not to cover a field. The Commonwealth can enact supplementary or complementary laws on the same field as laws that were enacted by the states. And thus, to avoid any claim of inconsistency, the Commonwealth can say that it has no intention of covering that particular field. If it does so, it allows state laws to continue regulating that subject matter as well. But two things should be said here though. Even if the Commonwealth expresses its intention not to cover the field, if any direct inconsistency occurs, that is, if we find a conflict of duties or a modification of rights, the law of the state will be inconsistent with the law of the Commonwealth nonetheless, according to section 109. And the other thing is that the Commonwealth cannot legislate to retrospectively say that another law did not intend to cover the field. All in all, the express intention not to cover the field does not exclude eventual direct inconsistencies that may occur or indirect inconsistency that may have occurred in the past. Okay, now, what if the Commonwealth does not say anything about its intentions? How can we know whether there was an intention to cover the field or not? Here, again, we are standing on some shaky ground. There are generally three steps that we can take to assess the implied intention to cover the field. First, we need to look at the nature of the subject matter. Some subject matters demand a uniform treatment. If a uniform approach is considered necessary, that particular law on that subject matter may indicate that the Commonwealth law intended to cover the field. Moreover, we can see whether all aspects of that subject matter are dealt with by the Commonwealth law. If we are facing a highly detailed law one that regulates the conduct with precision, then we may be looking at a law that ousts states' laws because of this specificity. The same happens if the extent of the federal law is so great that it seemed to regulate the entirety of the subject matter. These two, about detail and extent of the regulation of the Commonwealth law, are basically the notions of depth and breadth of the legislation. The Commonwealth law has wide breadth and profound depth. One could well be before a law which impliedly covers the whole field. Hey, leave a like to this video if you are considering it useful. and subscribe to our channel for constant videos about Australian constitutional law. Okay, let me summarize what we've seen today. The covering of the field test is a form of indirect inconsistency that brings the application of Section 109 of the Constitution to displace relevant state laws that enter a particular subject matter that has been thoroughly regulated by the Commonwealth. To assess whether the field had been covered and an inconsistency exists, we need to identify the field and see whether the Commonwealth Parliament had the intention to cover that area. To help us identify the field, we can characterize the two laws and look at the purposes of each one of the law's regulations. And to assess the intention, we need to see whether the Commonwealth has expressly stated its intention to cover or not cover the field. Or we need to check the implied intention of covering the field, which is manifested when the Commonwealth law uniformly deals with the subject matter or provides for a detailed, extended law on that particular field. Justice Dixon in the Kakariki case said this: "If it appears from the terms, the nature, or the subject matter of a federal enactment that it was intended as a complete statement of the law governing a particular matter or set of rights and duties, then for a state law to regulate or apply the same matter or relation is regarded as a detraction from the full operation of the Commonwealth law, and so as inconsistent." If you want to refresh your memory of some cases where this and other tests were used by the High Court of Australia on the application of Section 109 of the Constitution, check out the video appearing on your screen. Don't forget to leave a like to this video and to subscribe to our channel, and I'll see you next time. Ciao!